In today's video, I'm going to talk about a question that we hear a lot here at Triangle Smart Divorce, which is, when will my spouse be required to pay my attorney's fees? This is a question that comes up quite commonly, and it is an area of law that we have handled hundreds of times here at Triangle Smart Divorce. I'm going to explain when your spouse might be, notice I said might be required to pay your attorney's fees. First of all, you should also know that your spouse could agree to pay your attorney's fees. I know, for some of you that sounds crazy, but it does happen. I serve as a mediator. I also have been to mediations. My entire legal team has been to mediations, and oftentimes attorney's fees are a hot issue of negotiation during a mediation. That being said, we have advised our clients at times to pay attorney's fees, and we have asked strongly for the other side to pay our attorney's fees in other cases. And so don't think that you have to go to court to get some of your attorney's fees paid. It's possible that you could reach an agreement. Okay, that being said, we're going to focus most of this video on when a court might order your spouse or your ex-spouse to pay your attorney's fees. Basically, there are three substantive areas of the law that attorney's fees are related to. One is what we call alimony and post-separation support here in North Carolina. It's also known as spousal support. But basically the gist is, if you're coming to court and you're having to go to court to have the court tell your spouse they have to pay alimony or post-separation support, you probably also don't have the funds to pay an attorney. You probably also don't have the funds to live during that period of time, and you've borrowed money from friends, or you've put money on credit cards, or you have paid your attorney with a loan from someone else, any of these types of things. And so the law says if you're entitled to the relief that you're seeking, if you're entitled to alimony, post-separation support, and you don't have the means with which to subsist, to live during the pendency of the action, which is a fancy way to say during the period of time from when you ask for support and from the court actually orders it, then you might be eligible for attorney's fees. So we'll talk in a moment about how the court awards attorney's fees and how they determine what attorney's fees are reasonable. But for now, know that you can be eligible for attorney's fees if you're entitled to alimony and post-separation support. Another area of the law where attorney's fees are available to you is child support. Very similar standard to the spousal support we just spoke of. You have to be entitled to receive child support. You have to be proceeding in good faith, so you just can't bring a bad action. Which really means that if your spouse is paying you adequate support and you sue them, you're probably not bringing that action in good faith. You're probably just trying to be a pain. And so the court says we're not going to reward you for those situations and give you attorney's fees. And likewise, just like support, you have to have insufficient means to live until the court decides it. However, you also have to show that the spouse, or in the case of unmarried couples, that the parent of the child has refused to pay adequate support, and that forced your hand into filing the lawsuit. So, for instance, if the court was to say, hey, the reasonable amount of child support for Mr. Smith to pay is $1,000 a month, and Mr. Smith has been paying $900 a month, it's probably not very likely you're going to get attorney's fees. If Mr. Smith has been paying $1,100 a month, it's virtually assured that you're not going to get attorney's fees, as much as anything can be certain in court. But if Mr. Smith has been paying $0, Mr. Smith has been paying $100, Mr. Smith has been paying $500, exactly where that bright line ends, we're not sure. Kind of depends on your judge, to be honest. But we know that you have to show inadequate support under the circumstances. A third substantive area where you may be eligible for attorney's fees are in custody cases. And same showing as child support, except for the requirement for adequate support, obviously, because now we're just talking about custody. You have to be entitled to the relief you're seeking, you have to be acting in good faith, and you need these attorney's fees to meet the other party on equal footing, or to be able to live during the pendency of the action while you're fighting about custody. Okay. Now, all the other areas where attorney's fees might be available to you are more in the nature of sanctions. The court is penalizing somebody because they haven't done what they're supposed to do. So we see this in equal distribution, we see this in contempt cases, and we see this in motions to compel cases. What the heck are those things, some of you might be asking? Well, a motion to compel is when somebody is not complying with the discovery process, with depositions, with answering questions, with producing documents, by turning over data, by turning over documents, and so on. And so if you have to take them to court and have the court order them to do what they are supposed to do, then you can receive attorney's fees. Note, however, here, if the judge finds that you have asked for way too many things, too broad of a time frame, too extraneous, irrelevant stuff, the judge could say, you should have to pay the other side's attorney's fees because you asked really bad questions and you're just trying to harass them with discovery. So that one goes both ways. Contempt. Contempt is a situation where somebody has not done what they are supposed to do that they were ordered to do. And in that situation, in civil contempt situations, the court is trying to get them to comply with the order. And so the court can order attorney's fees in that case because you had to take them to court to get them to comply with the court order. And so that's sort of the penalty for not complying. And lastly, in equitable distribution, like I mentioned, the other side could obstruct you. They could delay the process. They could try to harm you and prejudice you and keep you from your assets, keep you from getting your personal property, keep you from knowing their values of things, and really delay the entire process of property division. And if that is the case, and a court determines that it's prejudicial to you, it's harmful to you, that it puts you behind the eight ball and it has cost you money, and it is delaying the process, then the court can order attorney's fees in those situations too as a sanction for someone willfully obstructing or delaying the process, or attempting to do so, actually, that also. So let's talk about the amount of attorney's fees. The court has the authority to order your reasonable attorney's fees. And so, as a lawyer, we love that word, right? Reasonable. What is that? It's in the eye of the beholder. In this case, the judge is the beholder. And so the judge has been told by our higher courts that the judge has to look at the nature of the services that were provided, the worth of those services provided, the scope and the complexity of the case, the time, the skill, and the labor expended by the attorney, the comparison of your attorney's rates to other comparable attorneys in the area and what their customary charges are, and also whether or not the other side increased those attorneys' fees by doing any sort of shenanigans, for lack of a better word. Basically, they were trying to run up your fees by just wasting your attorney's time or doing just nonsensical things. So, if you have any questions about all of this, it is kind of a complicated area, feel free to call our office. We'll be happy to talk to you about the underlying claims that you may have and whether or not it's possible that your spouse could be ordered to pay your attorney's fees. Thank you for watching.